Tuesday's proceedings in the ongoing election petition hearing could at best be described as heated and forceful. Dr. Michael Kpessa-Whyte, second witness for the petitioner, brought the courtroom to life in the cross-examination of his testimony before the court.
My lord, unfortunately, I can't tell who is talking. May I know who is talking? I can't see or whoever was talking right now. I don't have to see. Oh, okay, I see. All right, that's fine. I could only hear voices, so that's why I'm asking.
The primary question of how he and his colleague representative stationed at the National Collation Center for the petitioner melted away from their duty post became central to the cross-examination.
It is part of your duties to be there at all times. At least you are two. So if one is out, the other is there. Is that correct?
That's supposed to be the case, my lord.
Now, it is therefore, in my view, wrongful on your part to be suggesting that both of you left the strong room on the 9th.
We only exercise the option of going to see the petitioner because the first respondent had asked us to do so, and we had no reason not to believe that she was acting in good faith, only for us to realize we were deceived into getting out of the place.
I'm putting it to you that you know that the chair of the EC has no power to instruct either you or Nunu.
My lords, I know that.
So, I'm furthermore putting it to you that if you left the strong room, you did so on your own volition and based on your own judgment.
My lord, that's not correct.
For the Electoral Commission's lawyers, this was simply a concocted story to cover up for the witness's failure in discharging his duties creditably.
Was in the relation of your duties to the petitioner.
My lords, we never walked away.
As a result of you being in the relation of your duty, you then concocted this story and fed it to the petitioner, leading to the filing of this ill-fated action.
My lords, if this was ever a concocted story, we would not have left our laptops and our working tools in the EC's premises in the strong room.
But for the bench, it was simply unacceptable that the witness vacated his responsibility to the former president on the night of the declaration of the presidential election results.
So if there was concern for you to leave, and in a heightened, circumstance like that, do the two of you go?
Madam, sorry.
No, please, because you see, you were there for a purpose.
Yes,
for
my
the
lord.
petitioner, his eyes, body, everything was you.
Yes, my
You
lord.
were going to confer with the petitioner.
Yes.
What were you expecting him to say? Because you were the ones receiving the original results. So if you have to go and confer with the petitioner, wasn't it enough for one of you to go so that one stay around and see exactly what is happening?
My lord, with the
Looking
greatest,
at the atmosphere.
my lord, with the greatest of respect, the question itself suggests that the first respondent cannot be trusted.
No.
And therefore, we should have left one person there. I indicated to this honorable court, my lords, that we acted in good faith.
Your presence in the strong room was to see to the cause of the petitioner, but not to take instructions from the first person. You were asked this question and you admitted, you said yes.
And I indicated that.
You said yes, you were not to take instructions from the first respondent.
My lord, yes.
So, when the first respondent said, go and consult the petitioner, what were you going to discuss with the petitioner? You were in the strong room for a purpose. He told you to go and consult the petitioner. On what? I want to know.
My Lord, on the specific irregularities that we have brought to her attention, and she did indicate also that the reason she was asking us to do so that all the stakeholders, including the NPP, Peace Council and others, could be invited to ensure that we have a credible results before the announcement is made.
But you know that part of your duties in the strong room, at the end of the day, if you have refused to sign, was to indicate the reasons why you had refused to sign.
In the estimation of lead counsel for former President Mahama, Chachu Chikata, however, this could only amount to harassment of the witness.
Is entitled to his opinion about what the petitioner did, in terms of factual evidence about what he did and the reasons that he has answered. He has, in terms of his worship can have his opinion. That's his opinion to have, and he can have it as well. But in terms of what the petitioner did and why he did it, he has answered the question. So I don't think he can be harassed with these opinions.
Other members of the bench also took interest in the question of Form 13.
You said you received training or before assuming your duties.
Yes, my Lord.
So you've seen the Form 13 before?
Form 13?
Yes.
I have seen the Form 13 during the training process, yes.
All right. I'm going to show you a copy of the Form 13 that has been brought to this court.
Okay.
It's not in evidence yet, but I'm going to show it to you. Do you see a column that is headed reason for refusal to sign?
Yes, my Lord.
Thank you.
And my Lord, if I may, this is not Form 13.
What is it?
Only the first respondent can answer. Because if you look into the CI 127, a sample of the Form 13 is there. It requires you to list the regions and list the candidates and their individual votes as obtained from the regions. This form only listed the candidates, the votes they obtained, and then subsequently had agents and the candidates and signature. So this is not...
The court stands adjourned till Wednesday, February 3, to consider former President Mahama's application to inspect documents in the custody of the Electoral Commission.
The evidence of Dr. Kpessa-Whyte made it abundantly clear that the chairperson of the Electoral Commission on that very day acted in bad faith. He made it abundantly clear that when they were asked or instructed to go and then consult with the petitioner, that is His Excellency John Dramani Mahama, on some of the observations that they had made of irregularities that were significant in terms of the credibility and integrity of the results. They left in good faith in the expectation that after consultation they were going to come back and then continue with the process as stipulated by law. However, as you all witnessed, that was not to be. What happened on that day when she decided that she was not going to wait for them out of respect and courtesy and in accordance with due process of law to consult with His Excellency John Dramani Mahama before coming back for them to redress the issues that the concerns that had been raised, shows the utmost bad faith that she exhibited. There was a lot of questions relating to the so-called Form 13. Now, that is the presidential elections declaration of presidential results form. Form 13 is not a figment of anybody's imagination. It is a creature of statute. It is in CI 127. Now, Dr. Kpessa-Whyte made it abundantly clear, and I am sure this will come out during cross-examination, that what was shown to him was not Form 13.
You would notice
that it's not just an interchange of words, instruction and asked. And I want you to take particular notice. When you read the petition, when you read the witness statement, the witness statement says, we were asked. Check the definition of asked. Now, in the witness box and under oath, he seeks to amend that and escalate the claim by saying they were instructed. And that's why you find the Venerable Akoto Ampaw did not take too much time in his cross-examination. He asked one key question. He says, I put it to you that you know that you cannot be instructed by the chair of the first respondent. And you heard under oath, they could no longer tell that on truth. He said, yes, we cannot be instructed. Another matter that is being settled is the attempt of the petitioner and his witnesses to surreptitiously question the results by discrediting their own agents. You notice that initially from the beginning of the case, they sought to make an argument that numbers had been cooked up and that the EC's computations were incorrect. One of the key things that is becoming interesting is why Rojo Metil-Nunu himself did not mount the witness box, take the oath, and say that he was instructed. We believe if he had done that, he would have been caught for perjury, because he cannot take an oath and tell an untruth. And that is why they have resorted to Dr. Kpessa-Whyte, who now admits that he never spoke to or was never spoken to by the EC chair, yet he was a subject of an instruction and he was instructed. But the one who heard the instruction, the one who went to the office, is alive, is available, but refuses to take the witness box. We think that it is becoming very clear that as these matters are settled, and as we connect it to the principal issue of did anybody get more than 50%, was the declaration in breach of Article 63.3, the key questions will now come out and be answered.